Number 16, Anderson v. Commack Fire District.
Good afternoon, and may it please the court. Tim Hannigan of the Hannigan Law Firm on behalf of Appellant Commack Fire District. Your Honor, I respectfully request 3 minutes for rebuttal.
You have 3 minutes.
While this court has time and again properly applied Vehicle and Traffic Law Section 1104, the decision appealed from nullifies the express language of that statute with respect to emergency operation of authorized emergency vehicles belonging to fire districts and must be reversed. In appealing this matter, it's clear that both the Second Department, the majority of the Second Department, and the trial court relied exclusively on General Municipal Law Section 205B, which is a negligence shifting statute, and applied that statute to rules of the road, which it should not have done. Vehicle and Traffic Law Section 1104 was adopted in the 1950s, nearly 20-plus years after General Municipal Law 205B, and applies in certain instances that this court has time and again referenced, most recently in
All right,
Commack.
but is your position that there's no way to harmonize them? One applies in a particular sphere and the other applies in a different sphere? But if not, then how would you harmonize what appears to be the plain language of 205-B? The fire districts are liable for the ordinary negligence of their firefighters.
So, Judge
Volunteer
Rivera,
firefighters.
Judge Rivera, I would harmonize the statutes as much of the same way that this court did in Thomas. General Municipal Law 205B applies all the time, unless the specifically enumerated vehicle and traffic operations outlined in Section 1104 sub B occur, and unless there is a vehicle engaged in emergency operation.
Yeah, but my problem with that argument is that 205B refers specifically to the fire district, and 1104, when it comes to the standard of liability, is referring specifically to the driver. And one would think, if the intent is as you assert, that 205-B would have made clear that, right, that somehow, or excuse me, 1104 would make clear that the fire districts are subject to the same standard as the firefighter.
So, and that's the same path that the Second Department went on in the majority. However, when you look at the definitions contained within the Vehicle and Traffic Law, specifically Section 1101, which defines authorized emergency vehicle, and then Section 115-A, which defines fire vehicle as belonging to, among other owners, a fire district, it's clearly, a fire district is clearly captured within the scope of municipal owners subject to the protections afforded under Vehicle and Traffic Law Section 1104.
It says it's the owner. I'm sorry, perhaps I'm misunderstanding your argument, but all 1104 is referring to is the liability of a driver. Those sections don't say that the fire district is the equivalent of a driver.
Correct, and that's the same case in any time an emergency vehicle is involved in a motor vehicle collision or other incident. The same with police, city-owned, village, town, any sort of municipally owned emergency vehicle operating. But for purposes of this case, what we're dealing with is vicarious liability. So it is, of course, only the driver's liability that's to be considered, and there's no question on this record, because there's been no appeal from that fact, that reckless disregard applies to the actions of firefighter Muhlenberg. And under a pure theory of vicarious liability against the fire district, that liability, reckless disregard, is imputed to the fire district.
But 205B is also about vicarious liability in the way you're suggesting, and it does impose a different standard. Would not the legislature have done the same here if that was the intent?
So I believe the legislature did do that. So General Municipal Law 205B was enacted in the 30s to create liability for fire districts where none previously existed.
Yes, and as a consequence, when 1104 was enacted, the legislature was well aware of the existing statutes.
Yes, and 1104, when enacted, was allowed and included fire districts among the municipal owners of vehicles for purposes of affording those protections. And I guess what we're looking at here...
I'm not sure why you read 205B as creating vicarious liability for the fire districts instead of just liability for the fire districts.
It is. It's just a negligence shifting statute. I agree with that.
Well, why do you say shifting?
So when looking at the negligence of a vehicle operator, like this court did in Thomas when it applied General Municipal Law 205B, you look at the actions of the driver only. And just like in this case, there are no specific allegations of harm or wrongdoing as against the employer fire district at all. So only the actions of the driver can be evaluated. And in the event that the driver, as in Thomas, is liable in negligence only, that negligence is imputed to the fire district under 205B. It's designed to prevent volunteer firefighters from having personal liability for operation of a motor vehicle.
Well, they're not absolutely absolved from liability.
Correct.
Okay.
But for purposes of negligence, when a volunteer fireman, as in Thomas, is not operating an emergency vehicle but still fulfilling their duties, their negligence is imputed to the municipal fire district for which they are serving.
And so you're reading 205B, if I understand it correctly, which includes willfulness, right, so that the firefighter could be responsible if it were willful, right?
Yes, yeah.
So you're reading it to say that the standard of negligence for 1104 circumscribes the scope of the district's liability under 205B, but the willfulness in 205B itself doesn't.
So, and to answer the question, 1104 does not apply all the time. It applies only in
If one of the conditions is met.
Yes,
Yes.
there are multiple
Yes.
conditions. It's got to be emergency
I got
operation,
that.
lights and sirens, and then one of the four.
But you're reading those into 205B, but you're not reading the willfulness part that is in 205B into the district's liability.
And I think we are, and this court has in matter of Dutchess County, in terms of statutory construction and reading these two together, because they need to be read together. When you see a later specific statute like we see here with 1104, and you harmonize it with General Municipal Law 205B, the only logical result from that, comparing the two, is that this particular class of operation outlined in 1104 has to exist as a special class. I see
There
my
are
time
versions
has
of
expired.
1104 that predate 205B, right? If you trace it all the way back?
Yeah, the bulk of the sections set forth in 1104 were adopted in the 50s. Thank you.
Good afternoon, Your Honors, and may it please the Court. My name is Scott Cesny, and I'm from Buttafuoco and Associates, and I represent the respondent, Courtney Anderson, in this matter. Here, the Fire District is attempting to escape its statutory liability for its volunteer firefighters' negligence, and therefore, this Court should affirm the Second Department's decision to deny summary
Mr.
judgment.
Cesny, why should a fire district be vicariously liable if a firefighter is not liable?
Well, as Justice Rivera pointed out, that 205B deals with the vicarious liability of the district when the firefighter is negligent, when they commit any kind of negligence on the roads within the fire district, or as this court pointed out in Thomas, outside of the fire district, even outside of their own, outside of a district-owned vehicle, as long as they're in the perpetuating of their duties as a volunteer firefighter.
But
So-
1104 is a more specific statute, right? So how do you square your view with Saarinen?
Well, Your Honor, with regard to how it's a more specific statute, it's a more specific statute with regard to the actions of emergency personnel as Kabir pointed out, in those four specific situations. However, Section 205B is a specific statute, and the only statute that deals with the liability of...
I understand what 205 does, but Saarinen, we applied the reckless standard to Messina, right? It was the village, and I understand 205 wasn't raised, or it wasn't discussed in there, 205B, but we seem to apply that standard under those specific circumstances. So are you saying we just didn't consider 205B in that case?
No, Your Honor, and the point that 205B was not raised there is again, it did not apply because it wasn't dealing with the volunteer firefighter and with regard to a fire district itself.
So is there
But
some
isn't that
reason?
what you're asking now, is the fire district's standard of liability?
Yes, Your Honor, and that's exactly it, is that this was a...
So what was the standard of liability we applied to the fire district in Saarinen?
It was a different scenario where the reckless disregard standard was applied, but that's not what needs to be contemplated in this specific situation, because the factual points are different, because 205B is very clearly met here.
But I guess going back to my original question, is that because we didn't consider 205B in this case, or is there some factual difference between Messina in that case and this case?
Well, in this case here, 205B is, every single criteria is met here, whereas Saturn it wasn't. Here, we have a fire district vehicle owned by the fire district, operated within the bounds and the public streets and highways of the district in accordance with their duties, and that's exactly what's happening here. And if we were to read 205, if we were to not apply 205B here to impute liability onto the fire district specifically, then 205B would have effectively no utility whatsoever, because this is exactly what...
Are you saying that the rule for fire districts is different from the rule for municipalities?
Yes, Your Honor.
And why, and do you have any understanding of why the legislature would have wanted that?
Well, yes, Your Honor. So with regard to the difference between, a city fire department or anything like that, it goes down to where the legislature specifically referenced volunteer firefighters as opposed to paid firefighters, police officers, things of that nature, where they're professional law enforcement and emergency personnel dealing with the situations. And you could see in section 205, 205A, 205B, they make specific delineations between paid and volunteer law enforcement and firefighters specifically in those statutes. And there's
You're saying the intent was that they be treated differently even though the work is the same?
Yes, Your Honor, exactly. And they should be treated differently because they're held to different standards in there. And one is a professional, where a paid firefighter that's hired by the city or appointed by the city or any kind of municipality in that jurisdiction, that's their job. That's what they're there to do. They're trained by, and they're responsible for their training by the city, by whoever employs them. Whereas volunteers are not necessarily subject to the same training, the same legislation. And again, they're treated differently by the legislature in multiple aspects, and they should still be treated differently here in this situation.
So under your rule, the fire district would be liable for ordinary negligence for volunteer firefighters?
Yes, Your Honor.
And that wouldn't apply to other firefighters, just volunteer firefighters in the fire district?
Well, yeah, and that's exactly the point from Section 205B. I mean, the title of the section deals and specifically references volunteer firefighters. And that's exactly the point here, is that we have a volunteer firefighter operating within the district itself and in a fire district vehicle in the perpetuating of their duties. And this is exactly the type of situation that was contemplated when 205B was drafted.
And 1104 applies to all firefighters?
So it applies to all firefighters, however, it does not apply to fire districts as 11...
No, but the distinction that you're drawing that is explicit in 205B, you're saying does not apply to 1104 conduct.
Correct, Your Honor, and as you pointed out, that it deals specifically with the drivers themselves, not the districts or anyone else. It deals specifically with the drivers, and that's exactly the point, is that the only statute, and this court nor any other court, as appellants pointed out in their brief, at the end of it, they said specifically that 1104 has never actually been applied to fire districts, a fire district-owned vehicle. And that's, I think, one of the most important things here, is they weren't able to find any case law in any of the districts, in any of the departments whatsoever in New York that the fire district was ever dealt with or had 1104 apply to it.
So 1104 has never immunized a fire district for the negligent operation of a fire vehicle during an emergency response?
That's correct, Your Honor.
That's by statutory design? Is that your assertion?
Well, exactly. That is, so what I'm asserting here is that there is no case law supporting appellant's argument that 1104 should immunize the fire district, because with the statutory construction itself between 1104 and 205B, if 1104 was to immunize the district here, it would completely render 205B useless and inert as a
Is there
statute.
anything in the language of 1104 that would indicate that, or are you extrapolating that from your reading of 205A?
I'm sorry, no. So it's from the language of 1104 and the case law that's determined it, specifically with regard to Kabir, which Kabir, as defendants.
1104 says this doesn't apply to fire districts?
It does not reference that it does apply to fire districts, Your Honor. And again, as there is so, I mean, we can't presume or read in words to the legislative intent unless it was specifically mentioned in there. And again, the clear,
Their view doesn't, I think you were saying it nullifies 205B, makes it of no consequence, right? Makes it irrelevant, inapplicable. But doesn't 205-B apply to more conduct than 1104? Isn't the conduct in 1104 a subset of the much broader conduct in 205-B?
yes, Your Honor, but, and this is exactly the point, is that what we have here is exactly meets every single criteria of 205B. It's a fire district-owned vehicle within the fire district during the application of their duties as
Well, it
volunteer.
meets 1104 too, right? I mean, the action that occurred.
Oh, absolutely. And volunteer firefighters, their main jobs, their main duties are to respond to emergency situations.
In emergency vehicles.
Absolutely.
And 1104 refers, I think, exclusively to emergency vehicles, right?
Right, and as does 205B, it refers specifically to fire district-owned vehicles.
And again, and I think you touched on this earlier, what would be the policy reason for carving out volunteer firefighters in 205B to a different standard of care?
Well, so just like as the intent is stated through the initial letters as that statute was being passed, it was to encourage volunteer firefighters to actually join the volunteer forces so they wouldn't actually be responsible for their negligence, that the fire district would be immunizing them.
And how does that relate to holding the fire district to a higher standard of care than they are held to? I don't understand the connection. So what's the policy reason after 1104 comes in not to apply it here? Why are volunteer firefighters different? Is there a higher risk in your view? Their conduct is more likely to be negligent if and you want to hold the fire district to a higher standard? What's the policy reason?
Absolutely, Your Honor. And I see my time is almost running out. If I can just respond to your question. Thank you so much. The policy reason for holding the volunteer firefighters to a different standard or a separate standard there's multiple factors, and one of them specifically being that volunteer firefighters are not professional firefighters. That's made very explicitly clear. They're not being paid for their responsibilities. And again, as the legislature separately held them to different regulations and rules throughout the general municipal law. So the fact that they are being treated differently and they're trained differently, they're not held to the same standards as professional firefighters. The cities are not responsible for their training necessarily. So at that point, if they're not being treated as professional firefighters and they're not necessarily held to the same standards as professional firefighters, that may possibly lead to an increase of potential damage if they're not as trained or as highly skilled in the terms of firefighting training capabilities in those ways, as opposed to a professional. So if they're driving around possibly
And is that view of volunteer firefighters and their training, is that anywhere in the legislative history of any of these statutes?
Well, no, Your Honor, but not necessarily in these statutes that we're talking about here with regard to the...
Or other statutes?
In terms of the training, it comes down to the fire districts themselves as they're created. So, and that's, I think, exactly the point, is that it's not a homogenized standard that the state or any kind of larger municipality would be able to govern.
Thank you, Counsel.
Thanks so much,
I'm sorry, if I could just add, I'm sorry. Just, the question was triggered based on what you're saying. So, okay, let's say all of that makes sense for one moment, let's just say that. Then why have the reckless disregard standard 1104 for all firefighters? If the legislature, you're saying some of this policy of a standard that almost immunizes them, not completely, obviously, and there is a difference. Well, do you agree there's a difference between the 1104 standard with respect to firefighters and the 205B standard with respect to firefighters?
Yes, Your Honor.
Okay, so, but both of them give certainly the opportunity for a firefighter to not be held liable,
Absolutely.
given these heightened standards. Why have that for all firefighters at 1104, given what you've just said about the professional versus the unpaid? Although I think there might be some legislative language about that, but let's see what you say.
Well, Your Honor, with regard to having the reckless disregard standard, it is actually relatively similar to 205B's standard that they reference with regard to willful negligence and, I forgot the exact.
Malfeasance?
Malfeasance, exactly.
205B, yeah.
We're talking about a lot of different standards, so.
Yes, yes.
So I think that goes in line with specifically the reckless disregard standard of 1104, where that's where the driver is actually held responsible for their actions when they express that reckless disregard, and that's exactly where the volunteer firefighter would be if they're willfully negligent or acting with any kind of malfeasance.
Okay.
Thank you so much, Your Honors.
In response to Judge Garcia's question, there is no public policy supporting any suggestion that volunteer firefighters are treated differently under the law than paid firefighters for purposes of operating authorized emergency vehicles.
Well, except that 205B looks like it does treat them differently, right? 205B gives the volunteer firefighters a blanket immunity for anything, not just 1104 violations, right?
Correct.
So
for
they
all
are treated
activities.
differently.
Yes, but when that activity is specifically relative to the rules of the road and operating authorized emergency vehicles, 1104 as the later specific statute comes in and supplants 205B for purposes of the standard of liability that applies.
205B might be broader than 1104, no?
Yes, I agree it is broader than 1104,
So why would you
but the
supplant it
later
with,
specific.
so you would supplant it with something narrower? That is, you would give the volunteer firefighters themselves less protection than 205B gives them?
No, Your Honor, so section 1104 is a later specific statute.
I understand,
that-
it's narrow, the protection given to the volunteer firefighters in 205B is they're not liable civilly for any acts done by them in the performance of their duties other than willful negligence and malfeasance,
Correct.
right? That seems to me, I mean, if I could choose between that or 1104, even in a circumstance where I'm running a red light, I would pick 205B, not 1104. It seems better to me.
I think they're both good, but the issue in this case is that 205B does not apply.
Well, because it's supplanted by the later enacted 1104, even though that may be less protective than 205B.
I submit that 1104 is more protective because it subjects the emergency vehicle operator to the heightened standard of reckless disregard. Finally, I did want to note the discussion about paid versus volunteer. Fire districts are political subdivisions of the state. They're governed by publicly elected public officers. They can pay firefighters, and many do. In Arlington Fire District in Dutchess County, North Greece Fire District in Rochester, there are combination paid and volunteer departments. The focus here is on the municipal owner and the liability that attaches to the municipal owner of the apparatus, and there is no distinction there. 1104 applies across the board when those specific
Sure, but I want
examples
to
are
get to
met.
this issue that you're saying 1104 is the more specific and therefore it controls. It is specific in a different way from 205-B. I mean, 205-B is specific to volunteer firefighters' specific kind of conduct, and it's specific to the fire district's liability, whereas 1104, of course, applies to all firefighters, not just volunteer firefighters. There is a difference in the standard with respect to the heightened standard for liability in these respective sections. So they're specific in different ways.
Yes, but 1104 applies and the focus is on the
But
actual
1104
municipal
applies
owner.
to all firefighters. It's
Correct.
much broader in that way than 205B.
Yes.
Yeah.
Thank you.
Thank you.